Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, counsel, you can please party your client.
Yes, I'd like to direct your attention to June 15th, 2023 and June 22nd, 2003. Did you fail to appear for a probationary instruction?
Yes.
And additionally, while on probation, you did accrue a new charge, correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, factually accurate. The court will accept your plea to the probation violations. Enter a plea of guilty based upon your, enter a probation violation based upon your plea of guilty, and that would be technical violations 1, 2, 3, 4, and 5. And counsel?
Your Honor, I saw the recommendation for 60 days jail. I asked that my client get credit for the time that she's been in since December 1st. I'd ask that it run concurrent with the admonishment that she's received from the charge that she just took a plea on. And then furthermore, she did ask that during this time in custody, if possible, she would like the opportunity to be tethered to treatment. Thank you, Judge.
All right, Ms. Bolchak, did you request to be tethered to treatment while you've been on bond?
Yes, just to try to have time. I mean, I don't think I personally need treatment, but I know that that was something that I asked for when I first got arrested. So I'll do the days, I'll do whatever it takes, but I really just want to get home.
Okay, ma'am, let me ask you a couple questions. Number one, if you don't think you need treatment, why did you ask to go to treatment?
I was trying to have like the days made up. I don't know if I don't really know. Because
ma'am, you asked for treatment, so why did you ask for treatment?
Get out of jail.
I'm sorry?
To not have jail time.
Oh, that's what I thought. Okay, so, and you don't think you need treatment? Given what's been going on with you the last year, you don't think you need treatment?
Honestly, no. I really found myself in here. I've been spending time with myself. I don't know. I don't feel like I need a guy or anything. I don't know. I just want to get going on life.
Well, man, the way you've been going on life, not a great start. How old are you?
25.
25. And now you have 3 drug-related convictions. 3. Your under advisement status is revoked. You had an opportunity to not have your possession charge on your record, and you didn't do a darn thing with probation. Not at all. You just ghosted us.
I know. If I get probation this time, I told myself, like, you know, it would be at least 6 months. That's all I would really need to get like clean, and you know, by summertime I'd be, you know, working. I really want to get a car. But aside from the job thing, just, you know, I want to draw and make music, and I don't know, I just want to do things for myself. And I like coffee again. I don't know, just things I've been drinking a lot of water. There's just a lot of things I wasn't doing before that like I've been doing since I've been in here. So I haven't been.
Ma'am, part of the concern, right, is when you get out, how are you going to continue to do stuff, right? That's part of what treatment is, and you don't think you need treatment. So
I've been to treatment 7 times. I've been to treatment like 7 times. I don't know. I know how to work the program. I know to go to a meeting when I need to. I know there's just different times. I know.
So you go through the motion. You go through the motions. So you just go through the motions. You don't really receive what it is that you're getting.
I really think I've learned a different way. I've been incarcerated this time, ma'am. I don't know, it's just, it feels different, it feels really different. I'm
Well, here's what,
willing to go through any probation that you think we need to, but, you know.
Judge, we're ready to hear the sentencing. We are ready to proceed, Judge.
yes, no, man, you're not getting probation, I can tell you that much. The court's going to, on 23405, the court's going to adopt the recommendation, revoke probation, close the case without improvement, $50 probation violation fee, 60 days jail. On 23739, the court's going to adopt the recommendation. Your under advisement status is revoked, your probation is revoked, $50 probation violation fee, 60 days jail. The court will know that that will be served concurrent. And then the court's going to also order on 232479, the court's going to order 93 days jail. Credit for your 15 days. That's consecutive with 23739 and 23405. And the court will suspend your fines and costs on that, on this matter.
What?
Any questions, counsel?
No, Your Honor.
Any questions, ma'am?
So, how many days?
Well, 60 on your probation violations plus 93, plus 15. So that's going to be, I can tell you exactly what that is, ma'am.
Is there any way I could do treatment?
138 days.
Is there any way I could do treatment?
And you told this court you don't need treatment.
Okay,
No, you told this court, the only reason you said that is because you didn't want to do the jail time.
no, that's
So
not,
you can do the jail time.
ma'am, I'll do treatment,
And quite frankly, ma'am, with your lengthy warrant status and you're absconding from probation, I'm not sure that you would not abscond from your treatment provider.
ma'am, I can't do 130 days.
Yeah, you said you didn't need treatment.
I do.
Problem was, when I went to sheriff, the people over.
I need help with housing when I get out of here. I'm gonna need.
I'm sorry?
I need help with housing when I leave here. You know, I have my.
Okay, I need that talking in the background to please stop.
Somebody in.
My court recorders indicated our record is a mess because of all the talking in the background. And what was that, Ms. Bolchak?
I really don't. I think I need treatment instead.
Ma'am, you were very clear. You've been to treatment 7 times and you don't need treatment anymore.
No, I do.
You know how to work the program.
No, I got a little ahead of myself. That's what I asked for when I first came in. Because I do have a drug.
Judge, potentially, Judge, I know that potentially she might be asking for some sort of mental health treatment, but I understand this docket does need to be moved along. So if necessary, we have to have the matter recalled later in the morning to potentially have it reevaluated. But I understand the docket does need to move along, Your Honor. Thank you, Judge.
Thank you. Ms. Bolchak, I'm not ordering treatment for you at this point because you stated that you don't need treatment and you only asked for it so that you didn't have to do jail time. Given that and the fact that you had absconded from probation with this court, the court is concerned that you're not going to abscond from treatment. So at this point, 138 days is what you're going to serve, ma'am. We're all done. Thank you. Off the record. Have a good day.
What makes this case so striking isn't just the sentence, it's the series of choices that led here. From the very beginning, the court is clear, methodical, and patient. This isn't a surprise hearing. This isn't a rushed decision. This is a defendant who failed to appear multiple times, picked up new charges while already on probation, and openly admits she did not take the court's prior supervision seriously, and that matters more than anything else in a probation violation hearing. Probation is not a suggestion. It's a contract. The court gives you freedom instead of jail, and in return, you show up, stay clean, and follow the rules. In this case, the judge lays it out plainly: multiple technical violations, ghosting probation entirely, and a lost opportunity to keep a possession charge off her record. Those aren't minor slip-ups, they're the very reasons probation gets revoked. The moment that truly changes the direction of this hearing comes when the defendant is asked a simple, direct question: if you don't think you need treatment, why did you ask for it? Her answer, admitting it was to avoid jail time, lands hard. Judges hear a lot of excuses, but what they value above all else is honesty paired with accountability. Here, the honesty comes too late and the accountability never fully arrives. Legally speaking, the judge's reasoning is consistent and sound. Courts do not order treatment when a defendant openly states they don't need it and has previously abandoned supervision. Treatment programs rely on participation and compliance. If someone has already absconded from probation, the court has every reason to believe they may also abscond from treatment. That's not punishment, that's risk assessment. You can hear the frustration in the judge's voice when sentencing begins. This isn't anger, it's disappointment backed by a record. The judge adopts the recommendations, revokes probation, and carefully calculates the jail time. 60 days here, 93 days there, plus additional time, some concurrent, some consecutive. This isn't arbitrary, it's precise. And when the final number, 38 days, is stated, it becomes clear that the court has reached the end of its patience. What's especially telling is that after the sentence is explained, the defendant asks again for treatment, only now, when jail time is unavoidable. From a legal perspective, that request carries no weight. The court can't ignore what was said moments earlier under oath. Statements in court matter. Once you tell a judge you don't need treatment and only ask for it to avoid jail, you don't get to rewind that record. This case raises an important question for viewers. At what point does personal responsibility outweigh second chances? The court gave opportunities, plural, probation, advisement status, the chance to avoid a permanent record. Each one was ignored. And while the defendant talks about future goals, jobs, art, music, a better life, the court has to rule based on past actions, not future intentions. So what's the broader takeaway here? Courts are willing to help people who demonstrate effort and accountability. But when someone treats probation like an inconvenience instead of a privilege, the system responds exactly as it's designed to. This sentence isn't about cruelty, it's about consequences. Now we want to hear from you. Do you think the judge made the right call here? Should treatment still be offered even when a defendant admits they don't believe they need it? Or does accountability have to come first before help can work? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.